Nice job, Howard. Good afternoon, happy spring. I'm Randy Heller. Doesn't feel like spring, does it? I'm Randy Heller with the law firm Gallet, Dreyer, and Berkey. We represent a few hundred co-ops and condos and building owners and landlords and developers, and I'm sure some of you have crossed paths with my firm already. I'm the head of their construction law department at that firm. I've been asked to speak about an interesting topic, but one a little bit off the beaten path, a little esoteric, and I'm going to turn you into construction lawyers in the space of about 10 minutes, because that's all the time that I've been allotted. But I think you're going to find it a bit interesting. The general topic has to do with what's the effect of the delays which may result to construction work that's going on at your building. Now, of course, strikes can have ramifications on somebody replacing a boiler in your basement, somebody doing roofing work, pointing work, somebody working in your building, a contractor with whom you have a contract. So now there's a strike all of a sudden, and it's inevitable that there's going to be delays in one way or another. What's the upshot of that? Who's responsible for that? Who eats the costs? If there are damages, and you know the construction work that gets stretched out has costs to the contractor, costs to the owner. So where does that play out? Okay, so let's make you smarter than most of the judges in this state in the next 10 minutes. Let's start with something you know about, and that's the time of the essence clause. Probably all know about that. Every single contract of sale for a purchase eventually gets around to having a time of the essence clause in it. And that means that whatever date is made time of the essence, generally the closing date, when you buy a house, it says the closing will take place on such and such a date, time is of the essence. What that means is that date is absolutely etched in stone, unchangeable unless the parties get together and mutually agree to change it. Miss it by a day, you're in material breach of that contract, and the other party's entitled to damages. No backsies, that's it, etched in stone. A lot of people who encounter the time of the essence clause in their purchase contracts don't realize that you can make any date in any contract time of the essence. So enter into a contract with somebody to put a roof on your building, state that it's going to be done in 6 weeks or by such and such a day. If you write time of the essence for that day, that contractor needs to be done by that day. Miss it by a day, he's in breach of contract and all of the damages that flow from a party being in breach of contract. No argument, hey, come on, it was only a day, I was close. Time of the essence sets a black line or a red line in the ground. You can't violate that. Okay, it's a good thing to have when you're an owner. You probably want to make those kinds of deadlines time of the essence. And in fact, among the damages that can flow from that, from a contractor missing that deadline, are either your actual damages, whatever additional costs happen to actually flow their way, or sometimes you'll put in your contract what we call liquidated damages. Those are the things you probably think of as penalties, like $1,000 a day for every day. The little lesson is don't call them penalties, because that will bust your ability to enforce it, but that's what we all conventionally know them to be. Okay, so far so good. So, but what happens if a contractor is delayed through no fault of its own? Say, as by a strike, caused by somebody else? Whether that becomes your problem or their problem is largely up to you. Now, it may be a little late in the day to do anything about it affecting a strike that's going to take place on April 20th, but we seem to have these seminars every couple of years, so here's a lesson to be learned maybe for the next time, or a lesson to be learned for anything which causes a delay, anything by which a third party, weather, war, police event, anything that might cause a delay. So hopefully you can take something out of this and use it in your day-to-day life. So, one of the things you can use if you put it into your contracts is something called a no damage for delay clause. that description kind of says what it's all about. A no damage for delay clause, if you write it into your contract, says to the contractor, if you are delayed from any cause, even a cause that I've caused, we'll get into that a little bit more in a second, you, the contractor, are not entitled to recover any damages for the delay that you encounter. No damages, no compensation. We'll give you time, we'll give you an extension of time. So those of you who might put yourself in the shoes of the contractor for a second say, well, thanks a whole heck of a lot, what do I need time for? Remember, there was a time of the essence clause in that contract. Time is very important, because you blow past that date, you're already in breach of contract. So if there's a delay, this clause says, caused by anybody else, or even by me, I'll give you more time, but I'm not going to give you any compensation for that. Can you do that? You can do that. You know something? For 100 years, you couldn't do that. I've been practicing just for the last 35, but up until 1983, going back 100 years, you couldn't get away with that. You could write that clause into your contract, and believe me, everybody did. And when it finally got to courts, the court said, come on, if you, the owner, really did something which caused the contract to delay, why should we let you get off the hook for that? I know it says we're going to give you no damages for delay, but look, if the owner did anything to interfere at all, we're not going to enforce it. Come 1983, there was a seismic change in construction contracts, and the highest court in New York said, you know what? You're all grown-ups. You all sit down at a table. You all negotiate a contract. If you both agree to language that says, even if I delay you, I'll give you time, but I won't give you dollars, why shouldn't we enforce that? And sure enough, starting in 1983, the court said that that would be fully enforceable. Now, if you're curious, there are limits. There are extreme limits to the amount of interference that you can throw the contractors away and still hope to get off the hook. But let me assure you, that limit is way, way the hell out there. And just because you are inept in your administration of a contract, just because you act slowly, just because you have people that are not good at responding to shop drawings or answering questions, just because you hire a lousy architect, that clause is still going to be enforceable and you will not have to pay damages. Only where you maliciously and deliberately, and trust me, it reaches that extreme, only where you go to that extreme will you be held liable for delay damages. So lesson number one, if you're in the position of entering into a construction contract, why not put a clause like that into your contract? And then, although there'll be a footnote we'll get to in a second, causes such as strikes, or Hurricane Sandy, or terrorism, and things like that, unless it's dealt with separately, will not obligate you to pay damages. Now, see, here's a takeaway from this. When you enter into a contract with a contractor, where do you go to get your contract? God forbid you just use the contract given to you by the contractor. Oh my goodness, what a wasted opportunity that is. But also, God forbid, if you just go to your file cabinet and pull out a standard form, middle of the road, down the middle, kind of fair, maybe AIA 101, 201 contract. Well, okay, it's standard, but what a wasted opportunity. You are the one hiring somebody, you're in the driver's seat, you finally have bargaining leverage, presumably. Go to a lawyer that specializes in these kinds of contracts and have a contract made that favors you. You want to be fair in the administration of the contract? Be absolutely fair in the administration. But you might as well draft a contract that favors you. Okay, so let's say you have this no damage for delay clause in your contract. But often these same contracts have what we call force majeure clauses, things that are excuses for delays, that will give a contractor an excuse for being late. They're often called like act of God clauses, because what tops the list is usually, floods, hurricanes, earthquakes. You can cross off from that list, you can add to the list, and we'll get to strikes in a second. But in fact, I had a client who was a contractor who allowed hurricanes to be crossed off that list, and now is bearing both the costs and the time that were resulting from Hurricane Sandy. So that was a very unfortunate situation. But you can add things to the list, and as I say, riots and terrorism and insurrection, all these things are not so infrequently added to the list of force majeure events in that kind of excuse clause in the contract. But what about strikes? Strikes are sort of on the cusp. Strikes are often added to that list as things that excuse the contractor from having to meet that time of the essence date, that give him a reason to be late. But I think when you come upon that issue, you want to make it clear that it's not strikes for which that contractor is itself responsible. It should be a regional or a national strike, not something that it's responsible for. Now, for instance, it may not happen all that much, but where separate gates are set up when there's a picket line, the contractor refuses to use the separate gate and refuses to work, that might be a strike for which it is responsible and would not be excused by that force majeure clause. So, in the small amount of time I've been allotted, I hope that there's just a couple of morals to the story. Obviously, it needs a lot more discussion and there's a lot more wrinkles to it. But are you using a contract which is tailored to your own particular needs and which benefits you, or are you just using a middle-of-the-road, fair, standard, because it's quick and easy kind of contract? It's truly a wasted opportunity if you're not, at least in the first instance, going to the contractor with your specific customized form. And if you're smart enough to have a customized form, you may want to consider being sure that the contractor's substantial completion date is a time of the essence date, so that there's an absolute line in the sand that cannot be crossed, and that you have a no damage for delay clause, so that even if the contract is delayed by third parties over whom nobody has any control, or by your own inept administration, and it's funny, the cases say that, your own inept administration is not reason enough to bust that clause. You're still protected, even if you're just merely incompetent, as many of us are, unfortunately. And if they insist on having a force majeure clause, which will give them a list of excuses for blowing past that line in the sand, you might want to look at that carefully and see how they treat strikes, just because that's the subject of this afternoon's conversation. But of course, you want to see how they treat weather. Are they given an extension of time for any cold weather? Look at this past winter. Or should it just be weather beyond, say, a 10-year average or a 50-year storm? And you can make it what you want it to be, but you have to give these things consideration. So a lot of it is up to you. You now know more about delays, I think, than many people in the city. If you want to know more about mechanics liens, another esoteric topic, you can read my article in this that's being handed out. Any questions about delays? Sir?
Under the force majeure clause, does it specifically have to be something that restricts the contractor from getting to your building per se? Like, let's say there was a strike, but you were outside, or there was some weather-related thing, but you were outside of the zone. Could they still come back and say, well, there was a Sandy, or there was, or there was terrorism, but hey, we were in the Bronx, or this or that? Or...
I think the question is a factual question of whether it actually does preclude them from getting there. Would a strike that keeps your trucks in the Bronx, and so the Teamsters strike that keeps you from getting to the job that really has nothing to do with the site of the job, some force majeure clauses have workaround language in it. You have to do everything in your power to mitigate the damage, and the delay ceases as soon as circumstances change that would allow you to get there. But it is a good question. Anything else? Good, I'll answer any questions later if you have any more.
Good afternoon, I'm Steve Kirkpatrick from Bldg, Winnick Goldman. I'm a partner in the litigation group at the firm and represent primarily building owners, residential, commercial, all different types of issues. that come up in managing their buildings. And among the issues that come up and may be exacerbated during strikes are warranty of habitability claims by tenants, where there's some sort of a decrease in service or disruption and they withhold rent, or they file complaints with DHCR, and then you have to defend. If you've done everything to prepare for the strike, then theoretically the strike shouldn't have any effect. Then the reality is that, you know, in past strikes there have been an effect. Elevators go down, boilers go out of service. You know, it's the end of April, so it should be warm, but you could have no hot water, and those are, you know, very serious things that the courts take seriously when considering tenant complaints. There are some protections. If you read through your lease agreements, most standard forms, the real estate board form, the Bloomberg form, have strike provisions that insulate you from some liability. In addition, the New York statute for warranty of habitability, which is real property law, section 235B, contains a carve-out that was put into place after an earlier strike when there was a famous case, Park West Village, where, you know, the garbage piled up and tenants went on a rent strike, and the landlord said basically this is terribly unfair, and the legislature did a carve-out and said that the warranty of habitability does not apply in the instance of a strike. But it's really, when you sort of dig down and read that provision, you know, it doesn't provide as much protection as you would think. Because first of all, you have to act in so-called good faith. You have to make a good faith attempt to cure the breach. And so, you know, what is good faith? If I were a tenant's attorney, I'd say, well, you know, this landlord, they should have done more to prepare. They should have hired a non-union contractor. They should have, you can come up with many, many arguments as to what they should have done. So it requires a good faith attempt to get around and cure the breach. In addition, the tenant still gets a benefit. The tenant gets a benefit to the extent of what you have saved in money as a result of the strike. And, you know, if you try to figure that out as a practical matter, what you will do is you will spend probably far more in legal fees, far more in management fees, in trying to, you know, do the calculations. And at that point, you know, why not just give the tenant a 5 or 10% abatement? So, you know, there is some protection if you get into housing court. You know, not a whole lot of protection, but it is something to keep in mind. If you have DHCR complaints, you know, fortunately, with the way DHCR complaints work, you're supposed to get written notice of the condition before a complaint is filed. A complaint is filed, you then have, you know, at least 20 days to put in a response. If you have cured and you know, the tenant doesn't dispute that, then what happens is your rent isn't reduced. If there is a dispute, DHCR will schedule an inspection. On the practical side at DHCR, you know, these issues really don't come up because of the time frame, unless you have a strike that goes for, you know, months and months, which historically is unlikely. Any you know, strike is going to be over by the time a DHCR complaint makes its way through the pipeline. The other area where you know, habitability issues and you know, where they become an issue is if you have court-ordered agreements. You know, for instance, if you settled an HP case, if you have some other type of court order where you are required to do work. I have been surprised, actually, in preparing, you know, for this. I went back and looked at, you know, some form agreements, you know, that are in place, including the standard HPD form that they will get you to sign if you go into housing court and settle an HP case. And those agreements do not have language that protects you in the event of a strike. Now, a judge may be compassionate, but I wouldn't want to depend on compassion. And since these agreements don't provide typically protection, you have to consider what are the ramifications. If you're under an order to do certain things, if you're under an order, for instance, the standard HP heat and hot water order says that for the heating season, and it's really more open-ended, but at least for the heating season, you have to provide heat and hot water, and you don't provide hot water, it's basically a strict liability offense, and you can be fined very substantially. So it's something, if you're under any of those types of orders, you have to take extra precautions to make sure that you're gonna be able to provide these services. I had mentioned lease provisions, whatever your lease provisions are, they are. I mean, it's now a month or so away. It's too late to be modifying leases, but it's something, if you get a complaint, it's something to go back and look at. Does anybody have any questions on habitability issues?